Thank you all for coming. I know there's a few more that'll be coming in. My name is John Mitchell. I'm the CEO of IPC, the Association Connecting Electronics Industries. And on behalf of the association's 3,300 member sites worldwide, I'd like to thank you for carving out some time today and to learn more about ITAR's treatment of printed boards. Today's workshop is an educational event designed to clarify ITAR controls on printed boards, an aspect of existing law that generates confusion within the defense contracting community. To that end, we have assembled an impressive array of speakers who can describe the law and speak to its applicability to printed boards. In addition, we're fortunate today to have the opportunity to have a very timely discussion about the State Department's proposed rulemaking for Category 11 electronics and its control on printed boards. Each rulemaking in this reform process generates great interest, and so I'm grateful that IPC can provide a forum for engaging the policymakers behind Category 11's proposed revisions. But before we turn to our agenda and our distinguished speakers, let me briefly introduce to you IPC and describe our members' interest in this export control issue. IPC is a U.S. headquartered global trade association that represents all facets of the electronics interconnect industry, including design, manufacturing, and assembly of printed boards. More than half of IPC's 3,300 members are located in the U.S., although IPC's international membership is growing rapidly, especially in Asia, where we have offices. Within the over $2 trillion global electronics industry, IPC is one of the leading sources of industry standards, training, market research, and public policy advocacy. In the last few years, IPC has identified clarifying export controls on printed boards as a public policy priority. IPC's decision to pursue this advocacy initiative was driven by our membership's concern about reports of unlicensed sourcing of printed boards for ITAR items from non-ITAR facilities. These violations of the law, in whatever measure they may have taken place, are likely inadvertent, stemming from confusion within the defense industry about the specially designed nature of all printed boards. Printed boards, sometimes referred to as printed circuit boards, are the central nervous system of all electronics. Without printed boards, consumer, defense, transportation, and all other electronic systems simply could not function. Despite their ubiquity, printed boards are never commercially off-the-shelf components. They're each custom designed for a specific end item. This design must include highly technical information about the workings of the end item. So when IPC argues for appropriate controls on printed boards, our desire is to safeguard both the board as well as the intellectual property of the item into which it is incorporated. Release of this intellectual property can allow our adversaries to replicate or compromise sensitive military technologies. IPC has urged the State Department to clarify the treatment of printed boards as part of reform. But given the inherent uncertainty around any reform effort, IPC members also felt it was important to educate the defense community about the current law. With this mandate, IPC launched Follow the Law, Protect the Board, an initiative to educate our customers and peers about the important issue through industry outreach and events across the country. In fact, we are currently planning a February event in San Diego in conjunction with APEX, our annual trade show, which features over 400 exhibitors covering over 125,000 net square feet of exhibition space and draws over 9,000 visitors. The centerpiece of this educational initiative is an IPC commissioned white paper entitled Applicability of ITAR to Printed Boards, authored by Peter Lichtenbaum, one of the nation's leading ITAR lawyers. This white paper offers a plain language explanation of the law and uses concrete examples to demonstrate the specially designed nature of printed boards. Now, to make the best use of your time, we've packed a great deal of information into a short period of time, so without further ado, let me introduce our first speaker, Peter Lichtenbaum. Peter's a partner with Covington and Burling and co-chair of their International Trade and Finance Practice Group. He has experience in a broad array of international regulatory compliance and trade matters, and has specialized experience in the aerospace, defense, and homeland security industries. Most recently, Mr. Lichtenbaum was Vice President of Regulatory Compliance and International Policy at BAE Systems Incorporated, where he oversaw the company's compliance. Previously, Mr. Lichtenbaum served as the Assistant Secretary of Commerce for Export Administration at the Department of Commerce. During his tenure at Commerce, he also served for 7 months as Acting Undersecretary of Commerce for Industry and Security. His responsibilities included the development and enforcement of strategic trade controls, regulation of foreign acquisitions that affect U.S. security, and oversight of the defense industrial base. Without further ado, Peter, thank you.
Good morning, everybody. It's great to see some friends in the audience, and for those of you who I haven't met, I hope I'll have a chance over lunch or during the course of our conversation. I'm hopeful that while this issue, has been a complex one for the printed board industry, for its customers as the OEMs, for government, that this will be a very useful event in bringing together the people who have a significant stake in this issue, and hopefully a couple of hours from now walking out feeling like we all pretty much are on the same page as far as what these products are and how they relate to the ITAR, both as it currently exists and as it may change as a result of the Category 11 revision. And in that respect, I think this conference is very timely as the Category 11 proposed rule came out, I think November 28th. So just, as we were planning the conference, great timing. Thank you, U.S. government. And comments will be due on that by January 28th or thereabouts. So we'll have a chance to integrate this discussion into comments that the industry might want to make or OEMs might want to make with respect to the Category 11 rule. I do, as John said, my background is as an ITAR person, as an export control person, and so I certainly don't claim to be a printed board expert, far from it. I mean, I'm sure people here who have forgotten more about printed boards than I will ever know. So, as I try to, for the benefit of people who, like me, are not printed board experts, explain something about printed boards that I've learned in the course of the last year or so, I'm glad if anybody, has a more educated perspective on printed boards than I know my limitations, and printed board circuitry is one of them. So, without further ado, this is what I wanted to try to get through, providing that background on printed boards, talking about the current controls, and a bit on how export control reform might affect the picture. So, printed boards, what are they? What do they do? It's basically, a card size or larger in some, for larger systems, sheet of fiberglass reinforced polymer with wires attached. And what it's doing is connecting various components into an electronic assembly in order to tell some other electronic system what to do. And so these things, as John said, these printed boards, you find them in almost everything these days, whether it's refrigerators or toys or fighter jets. And I think that's one of the challenges from an export control standpoint, is the very diversity of these products, because people see them in all sorts of things, and so they think, well, how can something so omnipresent in American in the American economy and society possibly be subject to ITAR control? And I think to understand that, we need to focus on the specially designed nature of printed boards. And a voice of authority in this area is the National Academy of Sciences. I'm going to cite them a couple of times because they did a useful report back in 2005, which I think is, bears reading. It was not focused on ITAR, but it does contain good background on this industry. It was focused more on the importance of the defense industrial base from a DoD standpoint. But so those of you interested in this industry may find that report useful reading from that perspective as well. And it's on their website. But an important element of printed boards is that they are usually product unique. In other words, that a printed board will be designed for the product into which it's incorporated. So it's telling a specific system what to do. It's not a COTS, commercial off-the-shelf item, that can be kind of put into some different system. It is for what it was designed for. And when I say the product into which it's incorporated, that's the specific thing that it's going into, recognizing that in our complex world of systems, that system itself can be a subsystem which goes into a larger system, which goes into a larger system. So just because a printed board may be installed on a as part of an assembly that's ultimately going into a defense product doesn't necessarily mean that that printed board is specially designed for a defense product. The question is, what is the product that it's specifically designed for? What is it actually immediately going into? And that's what is going to ultimately be important from an export control standpoint. Separate from the printed boards themselves, which are the hardware, you have the designs for the printed board. So in ITAR speak, that technical data, and that can take various forms. An electronic data file would be common, often with drawings that basically provides the instructions or roadmap for the electronic operation of the item that it's designed for. The data may also take the form of saying what materials need to be used in building the printed circuit board, special properties, where you put the elements of the printed board is a key element, and how that information is supposed to flow through the circuit board itself and to the system that it's going into. From a national security standpoint, the National Academy, again, a very authoritative source, stresses that the effectiveness of defense systems depends on the underlying printed board technology. And why is that? Well, the printed board provides the basic building block for military electronics. It's a situation where you might think, well, the technical data is one thing, but the product is another. In fact, as I understand, you can essentially understand the design from the hardware product. So insofar as the design itself contains sensitive information about the system that it's designed for, the board itself enables a skilled practitioner to deduce information regarding the design. And that in turn can allow reverse engineering of the system, so it could allow our adversaries to produce similar systems, not just the printed board itself, but could learn important information about the system that it's designed for. Or it could enable the adversary to counter our systems by disrupting them through various tools. And we'll hear more about that in a second. But both from an offensive and defensive standpoint, the printed boards provide an important, or safeguarding printed boards is important to national security. So these are some examples, and we discuss these in the white paper. So if you haven't got the white paper, I think it was an attachment to the program. You can take a look and have these discussed in more detail. But this shows you just a few, really, of the very important areas to U.S. national security where printed boards show up. Electronic warfare obviously is a critical capability, communications, avionics. These are the types of advanced technology that U.S. government forces rely upon to provide their edge. And so anything that jeopardizes or whose compromise would jeopardize the edge that U.S. forces have is concerning from a national security standpoint. And I've always found the IED detectors, a very poignant example of that, because we all know that is where many deaths have come for American forces in Iraq and Afghanistan, and probably will continue to come in conflicts around the globe. And so if you think about that our IED jammers could be potentially compromised if people understood the printed board of the IED jammer, that's something that gives me some pause. So this is just an illustration of where you find printed boards in a particular military product, the AMRAAM missile, and again, the Trident II. So you can see that printed boards are on these significant defense products. In the flight controls area, the design of printed boards for flight controls can reveal the data buses used in those controls, which are the communications channels between the flight computer and the aircraft control surfaces. So they're providing the instruction to the various parts of the aircraft as to what they should be doing at the particular time, the communications heart of the aircraft. And so learning how that communication is occurring obviously can provide critical information to adversaries about how to disrupt that communication and thereby disrupt the capability of the aircraft, because if you can't communicate with your systems, then you're not going to have a very effective aircraft. So as we think about the intersection now, having laid the foundation of the product, how does that connect up to the actual text of the ITAR? We know what the product is. We know it's national security sensitive when it's specially designed for a military product. From an ITAR current standpoint, of course, we have Category 11 being the military electronics category, which captures components that are specifically designed or modified for use with Category 11A or B equipment, except for such items as are in normal commercial use. So Category 11A and B would be other military electronics items as specified in Category 11A and B. Now you do have this exception for items as are such items as are in normal commercial use, and we might have some conversation later. The next panel or the panel after that may have views on how normal commercial use in Category 11C should be interpreted based on experience over the years. I think it's a a gray area in the ITAR, of which there are a few, and one probably that would benefit from consulting with the State Department, which administers, as I'm sure many, but perhaps not all of you know, State Department administers the ITAR through its Directorate of Defense Trade Controls, or DDTC. But, you know, for me as a former compliance official and now as counsel, you know, it might rarely be a black and white situation as to whether a particular product that you were talking about was in normal commercial use, and therefore it might be an area where you would want to err on the side of consulting, at least talking to, perhaps submitting a commodity jurisdiction request which allows the State Department to tell you whether something is in Category 11C or has fallen out of Category 11C based on its normal commercial use. And we do see that, as I'll discuss toward the end of my talk, that there are commodity jurisdictions that get filed with respect to Category 11 items. And then there's Category 8H and other similar components categories, which capture components. In the case of Category 8, which is the military aircraft category, it captures components that are specifically designed or modified for items in Category 8. So if you had a printed board that was specifically designed or modified for a military aircraft, let's say a military helicopter, then that would be captured either within Category 11C or in Category 8H. There's also a Category 8I, which would be the technical data that is directly related to the components. So if you had as we were talking about before, the design data for a printed board, and a printed board was controlled in 8H, the technical data directly related to it would be controlled in 8I, and there's this parallel tech data control in Category 11D for the 11C printed boards. So the tech data control is really derivative of the printed board control. So how do I think about the bottom line of where this ends up? Well, you know, it's consistent with how I set it out in the white paper, that essentially the export jurisdiction over the printed board or the board design depends on the product that it's designed for, which again is not necessarily the ultimate product that it's going into, but is the specific product that it's designed for, the system that it's actually helping to communicate. And that system may be an ITAR system or it may be an EAR system, EAR being the Export Administration Regulations administered by the Commerce Department. Those capture dual-use products, i.e. non-ITAR. I would say non-military, but the EAR increasingly are including at least some military products. In any case, the EAR is a lower level of control, although be warned, it is still control. It's not decontrolled when it goes to the EAR, as Kevin Wolf will tell us at lunch today. So the jurisdiction depends on the product that it's designed for. And in my view anyway, and we can have discussion about it, printed boards that are designed for defense articles should generally be presumed as ITAR until you hear in some way from DDTC otherwise. So, you know, as I mentioned, you have this Category 11C normal commercial use. You know, there probably are products that State Department has decided, even though they were originally printed boards specifically designed for a military aircraft, let's say back in the 1950s or 60s, that they have become an industry standard, and therefore State Department has made the determination that those are properly treated in as a commercial or dual-use product. But I think if you have a product, a printed board that's specifically designed for a defense article, it's the responsible approach, the risk-averse approach, and it's important to be risk-averse in this area, to consult with the State Department or at least with your inside counsel or outside counsel to, before assuming that a product that's specifically designed for a defense article can be treated as a EAR or dual-use product. In contrast, I think it's reasonable to treat boards designed for EAR products as being EAR boards, even if that EAR product will be installed on a defense platform. But you do need to be sure that the product that you're designing it for is EAR, and to be quite comfortable with the jurisdiction of the product it's going into, because that is going to be a critical piece in driving the jurisdiction of your product. Sorry, go ahead.
I'm sorry, is there a clear line when the last bullet point there, if you install the EAR printed board onto the defense platform, at some point would you provide a defense service?
Good question. So for those of you who don't do ITAR for a living, the ITAR doesn't just apply to products, but applies to something called defense services. And that exists where a U.S. person is assisting a foreign person in various activities relating to defense articles. So it could be the development or production or use, etc., of a defense article. And so the question would be, even though your product is designed for an EAR product, could you be providing a defense service because you're assisting in the production, let's say, of a defense article? Is that a fair summary? Okay. And look, it's a gray area in the ITAR, as many here will recognize. My view of the scope of defense services is that when you're selling an EAR product to a foreign military program, you are not thereby providing a defense service. And if you, even if you are explaining to that foreign military how your EAR product works, that's not a defense service, because you're still talking about your EAR product. Where you start getting into potential defense services is where you're explaining how to use your EAR product to make their defense article work. So there has to be some application-related advice being given. So if you look back to 2005 in the Hughes DirecTV case, which is on the State Department's website, I think that's a useful explanation of how this can go down, where Hughes had a dual-use product, software, but was working directly with foreign militaries to help them adapt their software to work with a military product, military encryption. And so Hughes ended up getting penalized for that. But in this situation where, let's assume your situation is simply, I'm supplying a printed board that's going to go into an EAR product that I know will be installed on a defense platform, I would say that doesn't rise to the level of a defense service, because you're only providing an EAR product. You're not involved in advice on how to use that product with a defense platform in order to make the defense platform do what it does. So it's, to me, it's no different than if I were, selling shares to a foreign military. I'm not explaining to them how to use my product in the context of a defense article.
Would it matter if, let's say you didn't do that, but let's say the service you gave for your EAR product that would be installed on the defense platform, let's say the service you provided went beyond what you normally provide to your commercial customers. I'm trying to think if that would make a difference. I understand this is kind of a gray area.
Well, it does depend on the facts, exactly what you're providing, and we could ratchet up the hypotheticals as law school professors like to do, and well, what if you did this, what if you did that? It does become case by case. I I've tried to set out a reasonably bright line, but it's only a Peter Lichtenbaum line anyway, so you get what you pay for. Now, there have been some commodity jurisdiction rulings in this area, and those of us in the trade do look to CJ rulings as pretty good evidence of how the department is approaching jurisdiction. You know, as I think it was Oliver Wendell Holmes says, the best predictor of what a court will do is what it has done in the past. So the voice of experience. And as we went around and talked to people as we were writing the white paper, this question often came up as, well, what has the CJ record been? There's, of course, limited information available publicly on the DDTC website, but there is some. You know, you can't just download all the CJ determinations that they've done. But they are impressively transparent, more transparent than the Commerce Department, in that they publish a chart of CJ determinations that they've made since 2010. You can go look on their website and take a look, search on printed board or whatever you want. And so we did that. We found a few that showed us. I'm sorry? Go ahead. Yeah.
I think it's related to what I have a CJ I'm trying to put in right now.
Mm-hmm.
I'd like to know a little bit more about the ones that are out there that were military. You might be the right person to ask this. Is there a way to get more detail on what's out there on the website? The ones that have been ruled on.
Well, not really. I mean, the agency required companies submitting CJs, and you probably have seen this as you're preparing yours. You have to agree to certain information being public. And so the information that's on the website is the information that the manufacturer has agreed can be public. So the agency is not really in a position to share more.
So you have to go back in even if it's redundant to something they've already done?
You could well, yeah. I mean, you know, you could try to talk to that manufacturer if you're on a friendly basis with them and see if they will share more. Sometimes people will share. You know, you could go in and do a pre-discussion with state about your product and see if they think this is something that you need to come in for a CJ on. But generally, they will tell you you should. So, sorry not to be able to be more definitive on that. So, you know, we saw at least 3 areas where they had issued rulings. You can see a couple of them were ruled as ITAR. Category 12 is kind of the night vision area. Category 11 is military electronics. You can see that these things may fall into different parts of the ITAR, not all Category 11, but sometimes in other areas. And then the last one was ruled EAR 99. So that's actually the lowest level of control under the Commerce Department system, the dual-use system. So it was ruled commerce, and state also didn't just say it's commerce, it's not ours, but they said it's EAR 99, so that's in a very low-controlled category. You know, I have a little familiarity with these items, and you know, the 1553, and some of you, I'm sure, are familiar. That's a heritage military standard from like the 1950s or 60s. So it was specifically designed as a military standard for military aircraft. However, it got picked up by industry and is in wide use. And I think that's probably a situation where they determined, you know, this is in normal commercial use. It's not something that we consider as sensitive anymore, and so we're just not going to try to control it at the State Department. It's interesting to me that they determined it to be EAR 99 because there are some more regulated categories than that on the Commerce Control List, like a 7B 99 or 7A 994 might come to mind as a avionics equipment not elsewhere specified. But in this case, they ruled it EAR 99.
No, that makes sense. I can see that.
Mm-hmm.
And it's the data bus, the 1553 data bus, and then the RN 429, the commercial data bus.
Right.
That literally is just, here's the flow of information from the host here on this daily information. So any instrument avionics system, like the screen where it's got the engine and all that, they plug into the data bus. It's just a data standard. So it accepts the information, lets it run to wherever it needs to get onto that bus elsewhere in the aircraft.
Mm-hmm.
So from a sensitivity perspective, not a big one. It would be the instruments or items that plug into that data bus that I can see being controlled elsewhere.
Yeah, no, I agree. I didn't mean to suggest they were wrong. I have seen both rulings from Commerce. I've seen 7A994 and I've seen EAR 99. So I think Commerce themselves, depending on who you get, might see it a little differently, but that's why lawyers are so useful. Yeah, I actually literally have a call after this conference to try to get my classification ruling before the right guy at Commerce, so it'll come out the right way. Don't tell the government I said that. But and then we've got the proposed rule that was released just a couple weeks ago, with which would propose to reform the controls, because previously we haven't had any mention of printed boards in the ITAR, and I think that's kind of been a source of some confusion, understandably, in industry. It's hard to know where your product is regulated if it doesn't say it in black and white on the list. There's a list, but it doesn't have my product. How do I know whether it is or isn't? And that's a bigger problem in the ITAR that the administration has been trying to fix for 3 years now, and maybe someday it'll fix it. They've been coming out, as many of you will know, but some of you may not, with rules in these various categories, whether it's category 8, which came out as one of the early categories, and just recently this category 11. They've got about 20 categories. They're working their way through. They're most of the way there, trying to make these controls more specific on the products, as opposed to just focusing on the design intent and saying, well, if you were designed for a military program, therefore you're on the ITAR. So they're trying to, and this is a laudable effort, trying to focus on what they actually care about, and that's hopefully going to focus their efforts and industry's efforts more tightly on what's important from a national security standpoint, and also be a lot easier for industry to comply with when it's more clear as to what is covered, and conversely what falls to the Commerce Department. So in the printed board area, IPC had urged in various earlier comments and in meetings that the department call out printed boards specifically in Category 11, given the confusion that has existed among the printed board industry as well as OEMs and sub-tiers. And so I think it's a good thing that the government listened to that. They have called out printed boards now. That's definitely a positive development, both printed boards and the technical data that's directly related to those printed boards. Now, I have to confess, I don't know what patterned multi-chip modules are, and maybe that's an area where somebody here does. I've talked to a couple people, they didn't know either. But I'm sure when we get to hear, Kevin will know, yes. Kevin Wolf knows all, but perhaps Mike Lachek will know, as I suspect this originated with the Defense Department. We'll ask him. And so, I think this is useful in that it refers to printed boards, for which the layout is specially designed for defense articles in this subchapter. So the subchapter being the U.S. munitions list, not just Category 11, but if it's specially designed for any defense article that's covered on the U.S. munitions list, then the printed board is going to be covered in Category 11. Now,
So in 10 years,
yeah.
this is going to apply to all 21 categories, not just Category 11?
If it's specially designed for a defense article in any category, then the printed board would be covered in Category 11.
That's a lot of stuff, James. That's a lot of stuff.
That's not about access really is backwards, and it's CGs that are already moved on, and maybe you might have to use a description to answer that. But it looks like some things that actually.
Well, good question. I think for those of you who couldn't hear it, I'll just repeat it. I think the question was whether this new rule could result in products that were previously considered as EAR, non-ITAR, would end up moving back onto ITAR as a result of this rule. And the administration says that's not what they want. They don't want this to result in rollback. At least State Department says that and Commerce Department says that. I'm sometimes less sure. I don't know if people have heard Defense Department say that. But, you know, I think if there are situations like that, that would be an important area to bring to their attention in the comments, because this rule is published as a proposed rule for comment. Comments are not due until the end of January, so there's some time to put it together. And I think it might or might not have an impact, but I would definitely bring it to their attention as, oh, by the way, you know, we're concerned that this product that has been EAR for many years would now be ITAR, and that's obviously never a good thing, because people have made investments based on the presumption that something is EAR. To be moving it back to the ITAR is very commercially damaging.
Well, it's also,
I'm sorry, but Peter, to you, John, is IPC going to put comments in that?
Yes.
You are.
We are finally instrumented.
Thanks.
this also, you know, understanding that a printed circuit board is in and of itself considered to be a part of the component. It's not a standalone missile or aircraft.
Mm-hmm.
So having this what appears to be a part of the component within Category 11, regulated across all USML categories, that's a first. I haven't seen that in any other category where a part of the component in a category applies then to every other higher level article across the entire U.S. munitions list.
Mm-hmm.
That's a pretty significant change in approach to the list.
And are you? What is the significance of that from a practical standpoint? I mean, I take your point from a regulatory construction standpoint, but do you feel that it has
Well, I'm concerned with
a broader significance?
one, first off, layout, which the layout especially is on top there. That's kind of a key word there.
Mm.
Yeah, there's so much gray in that bullet right there.
Mm-hmm.
Because I think you're going to have the new definition, especially designed.
Right.
Here, and then the other proposal for the commerce side was published on the same day. They're saying special design components for the items in the ITAR over here, and that's specifically listed there. So you got like specifically designed components of the layout. I think the final answer is going to be a lot of CJs.
Mm-hmm.
Yeah, this is just going to vary.
Mm. Yeah, I mean, I think what this means is that it is specifically called out, so it's not in a catch-all.
I think the intent is clear.
Yeah,
I think
right.
we're going to generate a lot of CJ and generating another gray area.
Yes, I agree.
It's a comment.
I'm sorry, go ahead.
Yeah, so
Brent.
from the manufacturer side, layout is going to be considered the same as artwork. And artwork, we already saw listed on your list of CJs that it's considered an ITAR cover.
Mm-hmm.
It's for an ITAR item.
Mm-hmm. Yeah, but I think understanding how the government understands.
Honestly, that's how
Right.
For me, this is really clear.
Right. Layout is a word you know.
Layout equals artwork, and there's function in that artwork.
Right.
I think it's clear, a little bit clearer, the common definition of special design. We propose definition of special design, I think it's going to cause a problem.
Well, and it may not be the place here, maybe just during the panel, maybe it is here, I don't know, but we also, as a manufacturer, face situations where, through our sales force, we're told, oh, the customer says this isn't covered.
Mm-hmm.
And sorry, folks, but we don't accept that. We have to look at it ourselves because we're taking business risk as well. So when you guys decide something is or isn't covered, it may or may not mean that your favored PCB vendor is willing to do business under those terms. And we do walk away with frustrations on both sides.
Right. Right. Remy.
Just I guess a higher level question here, because I don't know anything about printed circuit boards, but from a broad context, you've got the 600 series with the intent of trying to offer a level of protection within the CCL for all the items that we're trying to move over. Why is that inadequate, I guess, in this particular circumstance? Where you have other situations where you have things that are specially designed that are moving over, but in this case, that should not apply.
Mm-hmm. Well, that I guess that's ultimately a national security question, and I think it's a good question, but it may be one that Mike Lachak of the people here is best suited to answer. Clearly there are many things that are called out as remaining on the USML that are specially designed, and this is one of them. So why is it one of them? We have to ask Mike. I mean, from a regulatory standpoint, as opposed to the national security perspective, which Mike can give, I think, as you probably know, there is a difference in terms of treatment for 600 series items and USML items. 600 series items are eligible for license exception STA. These are not end items, so they'd be parts and components. And so perhaps there's some concern with these items. License exception STA, that's a strategic trade authorization, and it allows, under certain conditions, items that are covered by license exception STA can go to about 25 or 30 countries, close to U.S. allies. And the concern might not be with shipments to those countries, but losing control of these products once they get to those countries. So there is a regulatory impact if you move it to the CCL. Yeah.
We design a lot of printed wiring boards that use a lot of the data buses that you specify, and some of those boards go on ITAR products, some of them go on EAR product, and there's really no way to distinguish at a board supplier what kind of product that goes on. The function that it performs on the aircraft might be important, and it might be more of a critical thing for national defense that, hey, I'm putting this kind of a product on my aircraft, and the purpose behind the product, maybe the software that's being run on the product, but not the printed wiring board itself. The printed wiring board itself may be just a bunch of patterns on copper that really are no different than a pattern of copper for any other commercial product. It may, in many cases, be much less sophisticated.
Mm-hmm.
So I guess I've got an issue like the other fellows did here with the word layout, because for some products, layout might mean an array for an antenna, and the printed wiring board itself might perform a particular function that might be critical. But for many other applications, the word layout may not distinguish anything at all, other than the fact that they would get simple products on some of these aircraft.
So in that case where you've got the board, is it the board itself that's really the key to it, or is there a special chip on
Right.
Two comments. One is grammatically, that's not clear whether the layout refers to the circuit board or the pattern multi-chip module. So we may be kind of just whistling in the wind. The second is there is a growing commercial class of printed circuit board products where the board is the antenna. Because we can lay down very precise patterns, it's quite useful. There's a whole family of radars, for example, in the automotive segment, where there is no separate antenna, that is the board. So it's getting harder to say the board is just a communication vehicle versus it's becoming a specific component as well. So as you go into those kinds of things, it gets a little bit fuzzy again for me.
Yeah. Look, I think it's a good question, and I think you might want to provide examples to the government in the comment period if you feel that there are situations where the printed board isn't doing anything special in the military context. I think it may be hard for the government to draft regs with that level of precision. And they tend to err on the side of protecting national security if they don't feel that they can write a rule that is kind of a product-by-product rule. And you can always get released from, even if the presumption rule is that it is on the ITAR, they always have the discretion to say that this doesn't rise to the level of what we want to control on the ITAR. So even if you end up in that situation where this is covered, you may be able to get released by showing that your product is essentially equivalent to a commercial product.
Is this, do you think this is another one of Kevin's sort of catch and release scenarios? That's why he wrote it?
I think that would be overstating it. Because when they've been doing catch and release, they've said catch and release. They've said it out there, and they haven't really done that here. That might be something that the industry wants to suggest, that they model a little bit more on that, and at least provide the kind of the framework for industry to come in and say, we don't think this product should be captured. I don't speak for IPC on this issue because we haven't discussed this, but personally, I would think that as long as the State Department is making that judgment, that should be a reasonable approach from a national security and industry standpoint, and that might be, given the difficulty of writing product-specific rules, it might be a good process solution to the challenge of the very, the wide array of products in this area, some of which may be a lot more sensitive than others. All right, other comments?
Just leave this up for Candace and Mike.
Yeah, can the approach be further improved to provide greater clarity? How about it? I mean, there have already been some interesting ideas tossed around here, which would be fertile ground for comments and fertile ground for discussion with Candace and Mike, who have obviously been key drafters of this language. We were talking about perhaps having some language either in the rule or in what the agency says in response to comments on the rule, because when they publish their final rule, they'll publish the comments that industry put in, and then they'll publish their response to those comments, and those are often useful in interpreting the rule later as lawyers. And so they could put something in their response to comments that clarified how they interpret this language. That might be helpful. For instance, I think IPC's view, as I said, and mine, is that printed boards would be, by their nature, specially designed. And so there's a risk here from this language that somebody might say, well, my printed board is for a defense article, but it's not specially designed for that defense article, whatever specially designed means, and so I'm okay, I'm not on the ITAR. And, that probably reflects a kind of casual approach to specially designed, but the introduction of that term creates some potential ambiguity, and it might be useful for the agency to explain what this means so that industry at least understands how the government understands it. Anyway, I see Mr. Lachek standing in the hallway, so I'm going to step down. You've heard enough from lawyer, and you want to hear from the government. Thank you for your attention. I hope that's a useful start to the day.